Usually when we talk about like a medical diagnosis, there's this expectation of absolute precision.
Oh, for sure.
Like it's basically engineering, right? You break your arm, the X-ray shows that jagged white line on the screen.
Yeah.
And the doctor just points at it and says, there it is. That's the problem.
Right, right. It's binary. I mean, it's visible, it's quantifiable, and I think most importantly, it's comforting.
Exactly. Broken or not broken, it's simple. But then you step into the world of human rights.
Oh, yeah. Totally different ballgame.
Yeah. You look at international law, and suddenly that X-ray machine is just, well, it's utterly useless. We're looking at a diagnostic landscape that is incredibly murky.
Because, I mean, how do you X-ray human dignity, right?
Exactly. You can't. And how do you, like, mathematically quantify the overreach of a sovereign state?
It's near impossible.
So you're touching on the exact mission of today's deep dive. Welcome in, everyone. Today, we are attempting to decode the fragile, incredibly complex architecture of global human dignity.
Which is quite the task.
It really is. So for you listening, today you are stepping into the shoes of a law student. We're tackling what universities would call Unit 4, International Conventions on Human Rights.
We're basically doing an exclusive masterclass today.
Yeah, exactly. We're going to take a massive stack of foundational text treaties, conventions, historical conferences from 1968 to 1993, right down to domestic legislation, and we're going to figure out how they actually work.
Not just what they say on paper, though.
Right. We want to understand why they exist, the fierce historical battles it took to write them, and how they are enforced when the real world just gets messy.
Because it always gets messy.
Always. Okay, so let's unpack this.
Because
to even begin, we have to understand the philosophical baseline that makes any of this possible,
And that baseline is actually a radical departure for most of human history. I mean, for centuries, the law dictated that your rights came from your citizenship.
Like they were a gift.
Exactly. Your rights were granted to you by your king or your state or your parliament. But the foundational texts we're examining today, they flip that entirely.
Which is wild to think about.
It is. They're built on the premise that you have rights simply because you are human. Your dignity is inherent.
Right. And because of that, there's a hard, absolute limit on what any state can do to you.
Precisely. It's a fundamental shift in how we view the individual versus the state.
Like the blueprint of humanity.
Yeah.
And that blueprint really started to be formalized right after the Second World War with the International Bill of Human Rights.
Which is such an important starting point.
Yeah. Now, I always used to think this was like one old piece of parchment locked in a vault somewhere in Geneva, but it's actually an informal name for a combination of 3 distinct texts, right?
Yes, exactly. It's a triad. So first you have the Universal Declaration of Human Rights, the UDHR, which was adopted in 1948.
Okay, 1940.
And then much later, in 1966, you get 2 legally binding treaties. The International Covenant on Civil and Political Rights, which is the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, the ICESCR.
I want to stop right there on the UDHR, though. 1948. The world is quite literally smoldering.
Oh, absolutely.
I mean, the international community is looking at the Holocaust, at atomic weapons, at just the absolute industrial-scale destruction of human life, and they say, we need new rules.
And that's exactly what birthed the UDHR.
Right. So like Article 3 guarantees the right to life and liberty. Article 7 guarantees equality before the law. But, and here's my thing, it's called a declaration.
Yes.
So here's my pushback. If it's just a declaration adopted by the UN General Assembly and not a ratified legally binding treaty, isn't it just a global wish list?
Well,
Like a very eloquent terms of service agreement that nobody actually has to follow?
I mean, that is the most persistent critique of the UDHR. And honestly, from a strict classical legal standpoint, it's accurate.
Right, because it doesn't have police behind it.
Exactly. A General Assembly resolution doesn't directly create binding legal obligations in the way a ratified treaty does. But to just dismiss it as a wish list ignores how international law actually evolves.
How so?
Well, the UDHR was this necessary philosophical shockwave. It set the normative standard for the entire planet. And crucially, the moment it was adopted, the UN immediately instructed its legal architects to draft a binding treaty to give it teeth.
But wait, that drafting process took almost 20 years.
It did, yeah.
I mean, they didn't open those treaties for signature until 1966. Why the massive delay?
The Cold War. You really have to remember the geopolitical reality of the 1950s and 60s. The world was fracturing into two ideological camps.
The U.S. and the Soviets.
Right, and that fracture directly impacted how human rights were perceived. So the Western capitalist democracies fiercely prioritized civil and political rights.
Like freedom of speech, freedom of religion.
Exactly. The right to vote, the right to a fair trial.
Because those rights protect the individual from the state. They basically require the government to step back and leave you alone.
Precisely. They're often called negative rights because they require state restraint.
Right.
But the Eastern Bloc, the socialist and communist states, they argued just as fiercely that freedom of speech means absolutely nothing if you're starving to death.
Oh, wow. That's a compelling point.
Right. So they prioritized economic, social, and cultural rights, the right to work, to housing, to healthcare, to education.
And those are positive rights. They require the state to step in.
Exact.
Because you can't just mandate a right to health care by stepping back. I mean, you have to physically build hospitals, train doctors, spend millions of dollars.
That's the core difference. The ideological deadlock was so profound that they realized a single treaty would just never be ratified by both sides.
Ah, so they split it.
Yes. The UN made a pragmatic, though pretty controversial decision. They split the rights into two separate covenants. That's why we have the ICCPR for civil and political rights and the ICESCR for economic and social rights.
Okay, let's drill down into how those two treaties actually obligate a government. Because the mechanics are vastly different, right?
Completely.
With the ICCPR, the civil and political stuff, the obligation on a state is immediate. Like if a country signs it, they are legally compelled right then and there to respect those rights and provide judicial remedies if they violate them.
Right. There's no waiting period for free speech.
Exactly. But the ICSCR uses a completely different legal standard. And it's a phrase you hear endlessly in human rights law, progressive realization.
Yes, progressive realization.
Okay, stop there. Explain the logic of progressive realization. Because to me, that sounds like a massive custom-built loophole.
It does sound like that, I know.
I mean, if I'm a corrupt government and my citizens demand the right to adequate housing or education, can't I just say, well, we're progressively realizing it. We just don't have the funds this decade and completely escape accountability.
It is the danger of the mechanism, undoubtedly, but the logic is rooted in economic reality. You literally cannot legally force a newly independent developing nation to suddenly provide universal free higher education overnight.
Because they might barely have a functioning tax system.
Exactly. It's economically impossible. So the treaty mandates that states must take steps to the maximum of their available resources to achieve these rights over time.
But how do you even measure that? How does anyone know if a state is actually trying or just hiding behind the excuse of being poor?
Well, that's where the international monitoring committees come in. They don't just look at a country's wealth, they look at its budget allocation.
Oh, that makes sense. Follow the money.
Exactly. If a state says, we can't afford to build primary schools, but the committee looks at their national budget and sees they just spent $3 billion on a new fleet of fighter jets.
Busted.
Right. The committee can determine that the state is failing its obligation under the ICSCR. It's about priority. Even the poorest state is expected to provide minimum core obligations.
Like basic shelter, essential medicines, rudimentary education.
Yes. Progressive realization is a staircase, not a waiting room. You have to prove you are continually moving up.
I love that. A staircase, not a waiting room. That distinction is so vital. And I think it highlights how the global conversation evolved.
It really does.
If we jump forward in history a bit, to 1968, the UN held the first international conference on human rights in Tehran.
Yes, a major milestone.
It had been 20 years since the UDHR. The world had completely changed. Decolonization had happened, and dozens of newly independent nations from the global south were now at the table.
And the Tehran Conference of 1968 is a crucial pivot point because of that. It was the moment the international community formally recognized that human rights couldn't just be viewed in a vacuum.
Right.
The delegates in Tehran strongly linked human rights to economic development. They stated really clearly that you cannot meaningfully achieve civil and political rights without simultaneously advancing economic and social rights.
They also heavily targeted apartheid in South Africa during that conference, right? I mean, it was a massive global condemnation of institutionalized racial discrimination.
Yes, absolutely. Tehran was really the global South asserting its voice, pointing out that colonialism and apartheid were the ultimate violations of the UDHR.
Right.
It laid the groundwork for viewing systemic, state-sponsored discrimination as a global crime, not just an internal domestic issue.
Which perfectly transitions us into the treaties designed to outlaw the absolute worst horrors of state power. The things that go far, far beyond a government failing to fund a school or suppressing a newspaper.
Right. The darkest parts of history.
Exactly. We need to talk about genocide, slavery, and the crisis of refugees. Let's start with the Genocide Convention of 1948,
Okay.
because the definition of genocide in international law is actually much narrower and more specific than how it's used in everyday conversation.
It is deeply specific. The term itself was coined by a Polish-Jewish lawyer named Raphael Lemkin, who tirelessly lobbied for this convention.
Really? I didn't know that.
Yeah. And the legal definition doesn't just mean a large-scale massacre or massive casualties in a war. The absolute core of the legal definition is intent.
Intent.
Yes. It is defined as acts committed with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group.
So it's not just the physical act of killing. It's the psychological intent to completely erase a specific category of humanity from the earth.
Exactly. I mean, you can theoretically commit genocide without dropping a single bomb.
Really?
Well, the convention lists acts like deliberately inflicting conditions of life calculated to bring about a group's physical destruction, or forcibly transferring children of the group to another group.
Oh, wow.
Yeah. It's the systematic, intentional erasure that makes it the crime of crimes in international law.
But, I mean, proving intent in a court of law, especially the intent of an entire state apparatus, that has to be incredibly difficult.
Oh, it is the highest evidentiary bar in international criminal law. You have to prove that the perpetrators didn't just want to win a war or crush a rebellion.
Right.
You have to prove that their specific objective was the destruction of the protected group. But what's truly revolutionary about the Genocide Convention isn't just the definition.
What is it then?
It's the obligation it places on the rest of the world. It requires states to not only punish genocide, but to prevent it.
Prevent it. And that obligation to prevent, I mean, it sat dormant for a long time, didn't it? The international community failed in Rwanda. They failed in Srebrenica.
Sadly, yes. Major failures.
But those failures eventually birthed a massive conceptual shift in the 2000s regarding how we view sovereignty, didn't they?
Yes, you're referring to the R2P doctrine, the responsibility to protect,
Right.
which emerged from the 2005 World Summit. This is honestly one of the most fascinating developments in modern international relations.
Why is that?
Well, ever since the Treaty of Westphalia in 1648, state sovereignty was the golden rule. What a king or a dictator did to people inside their own borders was, frankly, their own business.
The international community had no right to interfere.
Historically, yes. If a dictator wanted to massacre his own citizens, the rest of the world basically had to shrug and say, well, it's his territory.
That's horrifying.
It is. But R2P shatters that shield. It establishes that sovereignty is not just a right to non-interference, it is a responsibility.
A responsibility.
Yes, every individual state has the primary responsibility to protect its population from genocide, war crimes, ethnic cleansing, and crimes against humanity.
And here is the kicker for you listening, the part that rewrites global diplomacy. The R2P doctrine says that if a state manifestly fails to protect its populations from these crimes, or worse, if the state is the one actually committing them, that responsibility yields to the international community.
Precisely. The international community then has the right and the obligation to intervene.
Wow.
Yeah. That can start with peaceful means like diplomatic pressure or economic sanctions. But if those fail, it authorizes collective action through the UN Security Council, including military intervention.
So it fundamentally means that sovereignty can be temporarily suspended if you are butchering your own people.
Exactly. It's a massive shift.
Okay, so that's the macro-level destruction of life. Let's look at another fundamental prohibition, slavery.
Right.
And I think a lot of people assume international law doesn't need to spend much time on this anymore, because chattel slavery, the legal ownership of human beings as property, was basically abolished in the 19th century.
That's a very common misconception.
But the Slavery Convention of 1926 and its massive supplementary convention in 1956, they paint a very different picture.
Because the nature of human ownership evolved. The 1956 Supplementary Convention is vital because it expands the definition to cover slavery-like practices.
Slavery-like practices.
Yes. The law recognized that you don't need a formal deed of ownership to completely subjugate another human being.
The conventions specifically target things like debt bondage, right?
Right.
Where a person pledges their labor as security for a debt that, surprise, surprise, can magically never be repaid.
Exactly.
But they also highlight something that gets overlooked a lot: civil marriages.
This was a groundbreaking inclusion. It covers institutions or practices where a woman is promised or given in marriage on payment to her parents without the right to refuse,
Oh,
or where a husband has the right to transfer his wife to another person for value, or even where a woman, upon the death of her husband, is legally inherited by his family.
inherited. Like a piece of furniture.
Literally. The international community correctly identified these practices as indistinguishable from slavery because the core element, the total deprivation of autonomy and the treatment of a human as transactional property, is identical.
The ultimate deprivation of autonomy also applies to people who don't even have a country to call their own. Which brings us to the Conventions on Refugees and Statelessness.
Right.
The philosopher Hannah Arendt famously describes citizenship as the right to have rights. If you don't belong to a state, you really have no mechanism to claim your human rights.
And Arndt's observation is the exact philosophical problem these conventions try to solve. The UDHR states everyone has a right to a nationality and a right to seek asylum.
But saying it isn't enough.
No. The 1951 Refugee Convention and its 1967 protocol had to define exactly what a refugee actually is.
And it's not just anyone fleeing a bad situation.
No, not at all. An economic migrant fleeing poverty is not legally a refugee under the convention. A refugee is strictly defined as someone who has a well-founded fear of being persecuted.
Persecuted for specific reasons, right?
Yes. For reasons of race, religion, nationality, membership of a particular social group, or political opinion, and they must be outside their country of nationality and unable or unwilling to avail themselves of its protection.
There's also a major caveat regarding criminal prosecution that I found interesting.
Oh, yeah.
If you, embezzle millions of dollars from a bank in your home country and the police are after you, you can't just cross the border and claim asylum because you are technically fleeing.
Exactly. Asylum is a shield against persecution, not a shield against legitimate prosecution for non-political crimes.
Right.
The convention explicitly excludes those who have committed serious non-political crimes before entering the host country.
Okay, so we've talked about states destroying populations or people fleeing states. But what happens when the horror is highly localized?
Like micro level.
Exactly, micro level. We need to talk about what happens when a single individual is locked in an interrogation room, utterly at the mercy of state agents.
Oh, this is heavy.
Let's examine the absolute line in international law. The Convention Against Torture, or CEDAW, adopted in 1984.
CAT is arguably one of the most uncompromising documents ever drafted.
I mean, both the UDHR and the ICCPR state that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment. But CEDAW goes much further, doesn't it?
It does. It provides a highly specific mechanical definition of torture.
The definition requires 3 specific elements. So first, it involves the intentional infliction of severe physical or mental pain or suffering.
Right.
Second, it has to be for a specific purpose like getting a confession, punishing someone, intimidating them, or for any reason based on discrimination.
Yes. And the third element is crucial.
The pain has to be inflicted by or at the instigation of or with the consent or acquiescence of a public official.
That third element is what distinguishes torture under international law from just, a random assault.
Okay, explain that.
Well, if a civilian kidnaps someone and beats them for a confession, that is a horrific domestic crime. But if a police officer does it...
Or if the police officer just watches a civilian do it and turns a blind eye.
Exactly. That is torture under CA. It is intrinsically tied to the abuse of state power.
Now, I want to present the ultimate hypothetical. It is the classic ticking time bomb scenario.
Ah, yes, the classic test.
It's the plot of 100 spy thrillers. The police have captured a known terrorist. They have verified intelligence that this terrorist has planted a nuclear device in a major city center and is going to detonate in exactly 60 minutes.
Okay.
Millions of lives are at stake. Doesn't the sheer mathematics of human survival demand that the state use any means necessary, including severe physical pain, to extract the location of that bomb?
That's a tough question.
Doesn't the right to life of millions override the right of one terrorist not to be tortured? I mean, honestly.
It is the most powerful ethical dilemma you can pose, and it is literally designed to find the breaking point of human rights law. But international law has debated this endlessly, and its answer is a definitive, unflinching no.
None. Wait, no exceptions for fates of emergency. What if a country is actively being invaded?
None. Article 2 of SECSI explicitly states that no exceptional circumstances whatsoever, whether a state of war, internal political instability, or any other public emergency, may be invoked as a justification of torture.
Wow.
The prohibition of torture is a jus cogens norm.
Just cogent. Let's unpack that term.
It translates to compelling law. In international law, a jus cogens norm is a peremptory principle that is so fundamental it is accepted by the international community as a norm from which no derogation is ever permitted.
No exceptions. Ever.
Never. You cannot treaty your way out of it. You cannot legislate an exception to it. Genocide, slavery, and torture are jus cogens.
But logically, why? Why let the ticking time bomb explode just to protect the dignity of the person who planted it? That's hard for people to swallow.
Because of the slippery slope of the legal loophole. Former UN Special Rapporteurs on torture have written extensively on this. Torture is unique because its entire design is to completely obliterate the autonomy and dignity of a human being, reducing them to a powerless object.
Right.
If you write into the law that torture is permissible only in ticking time bomb scenarios, you have legally authorized the state apparatus to possess torture devices, to train interrogators in torture methods, and to maintain torture chambers.
Oh, I see. And once the infrastructure exists, the definition of a ticking time bomb inevitably expands.
Precisely. Today it's a nuclear bomb. Tomorrow it's a kidnapping victim. Next week it's a suspected drug cartel leader.
And next year it's a political dissident who might know about a future protest.
Exactly. History unequivocally proves that if you give a state the legal authority to torture under exceptional circumstances, torture will rapidly become a systematic, routine tool of state terror. The absolute ban is the only way to prevent the contagion.
That makes total sense when you frame it like that. There's also a secondary protection in CA that is vital. The principle of non-refoulement under Article 3.
Yes. This dictates that a state cannot deport, expel, or extradite a person to another country if there are substantial grounds for believing they will be subjected to torture there.
So even if someone is in your country illegally, or even if they are a known criminal, if sending them back to their home country means the secret police will torture them, you absolutely cannot put them on that plane.
No, you cannot.
You're complicit in the torture if you do.
Correct. But making rules is one thing, right? Enforcing them in dark, soundproof rooms is another entirely. How do you stop something that inherently happens in secret?
This is where we get to OPCAT, the optional protocol to the Convention Against Torture, which entered into force in 2006. And honestly, this blew my mind because it relies on the psychology of deterrence through transparency.
It's a brilliantly designed mechanism. OPCAT establishes a two-pillar system: the International Subcommittee on Prevention of Torture, the SPT, and national preventive mechanisms at the domestic level.
Okay.
And their primary power is the power of unannounced visits.
Unannounced, they can just show up. No warning, no scheduling a tour.
Exactly. They can arrive at a maximum security prison, a local police station, a psychiatric hospital, or an immigration detention center and just demand entry.
Oh, wow, that's wild.
Yes. They can interview detainees in private without prison guards present. They examine the conditions, the logs, the medical wings.
So the whole philosophy is that abuse thrives in darkness.
Right. If a police captain knows that independent inspectors could walk through the front door at literally any hour of the day or night, the systemic, institutionalized use of torture becomes exponentially riskier.
And much harder to sustain.
Right.
There's also an incredible evolution happening right now in how the Committee Against Torture interprets the convention. We established earlier that torture has to involve a public official. But what if the terror is happening inside a private home?
This is the absolute cutting edge of international human rights jurisprudence. The committee is increasingly utilizing the doctrine of due diligence.
Okay, what does that mean in this context?
They are looking at severe violence inflicted by private actors, specifically rampant domestic violence, or human trafficking by private cartels.
But the state isn't inflicting the pain in those cases. So how does SINK apply?
Well, the state isn't throwing the punch, but what if the state creates the environment where the punch carries no consequences?
Oh, I see.
If a state knows that widespread severe domestic violence is occurring and its police systematically refuse to arrest the abusers and its courts systematically refuse to prosecute them, the state is acquiescing to that violence.
The state's deliberate inaction essentially deputizes the abuser.
Exactly. The committee is moving toward a consensus that a state's systematic failure to exercise due diligence to prevent, investigate, and punish severe private violence can elevate that violence to the level of torture or cruel and inhuman treatment under the convention.
That is a massive paradigm shift. It brings public international law directly into the private sphere.
It really blurs the lines, yeah.
And that blurring of the public and private spheres is the perfect gateway to talk about the World Conference on Human Rights in Vienna in 1993.
Oh, Vienna.
Because that completely rewrote the rules for half the global population.
The Vienna Conference of 1993 is a monumental milestone. The Cold War had ended. The world was really trying to figure out what a unified global order looked like.
And one of the biggest debates at Vienna was between the West, which pushed the universality of individual rights, and several nations advocating for cultural relativism.
Or Asian values, as some called it. The idea that human rights should be interpreted differently based on a region's historical, cultural, or religious background.
Meaning, don't impose your Western individualistic values on our traditional community-based societies.
Exactly. But the triumph of the Vienna Declaration was its resounding rejection of cultural relativism as an excuse for human rights violations.
They shut that down.
Completely. The Declaration explicitly stated, all human rights are universal, indivisible, and interdependent and interrelated. It asserted that while cultural backgrounds must be borne in mind, it is the duty of states, regardless of their political or cultural systems, to protect all human rights.
And Vienna did something else that was historic. It was the moment the global community definitively declared that women's rights are human rights.
Which I know sounds obvious to us now, but in 1993 it was revolutionary.
Because historically, international law dealt with the public sphere, right?
Yeah.
Wars, state torture, censorship.
Right. It ignored the private sphere, the home, the family, marriage, which is where the vast majority of violence and discrimination against women actually occurs. Vienna shattered that barrier, and it poured massive momentum into the enforcement of CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which had actually been adopted back in 1979.
Let's dig into CEDAW, because to understand it, we have to grasp the friction between two legal concepts: formal equality versus substantive equality.
Yeah. Okay, yes. This is crucial.
Formal equality is colorblind and genderblind. The law simply says men and women have equal rights and assumes the job is done.
But formal equality is a myth if the starting line is fundamentally rigged.
Right.
If society has spent the last 3,000 years systematically denying women access to capital, property ownership, higher education, and political power, simply passing a law that says we are all equal now does not magically fix the economic and social inertia of patriarchy.
It's like having a foot race where one runner has been tied to a tree for 10 years. You can't just untie them, fire the starting pistol, and say it's a fair race. Their muscles have atrophied.
That's a perfect analogy. Exactly. So CEDAW focuses on substantive equality making equality a reality in outcome, not just in theory.
Outcomes matter.
Yes. And to achieve that, it introduces its most powerful and deeply debated tool in Article 4. Temporary special measures.
Okay, let me play devil's advocate here, because this is where the friction hits the real world.
Go for it.
Temporary special measures mean affirmative action.
Yeah.
Quotas, guaranteeing that, say, 30% of a corporate board or a national parliament must be female.
Right.
If the entire underlying philosophy of human rights is non-discrimination, treating everyone equally regardless of sex isn't setting up a gender quota, technically discriminating against a qualified man who loses that seat. Isn't it reverse discrimination?
It is the most common legal challenge to CEDAW, and the committee tackles it head-on. The expert consensus in human rights law is that treating unequals equally only perpetuates inequality.
Because the system is already skewed.
Exactly. If you rely solely on merit in a system that has historically only allowed men to build merit, you will literally never achieve parity.
So the discrimination is viewed as corrective.
Yes. Article 4 specifically authorizes these measures to accelerate the attainment of de facto equality. But the text pivots on one crucial word: temporary. These measures are legal tools designed to correct historical imbalances. And according to the CEDAW committee, the absolute second that true equality of opportunity and treatment is achieved, these measures must be dismantled.
They are scaffolding.
Oh, I like that.
Yeah, you put the scaffolding up around a damaged building so the workers can fix it. But once the foundation is solid and the building can stand on its own, if you leave the scaffolding up, it's just blocking the view.
That is spot on.
If a quota continues after systemic parity is reached, then it becomes an unjustified privilege and constitutes illegal discrimination.
Exactly. That is the perfect way to understand it. And the global data proves why that scaffolding is desperately needed. We aren't just talking about corporate boardrooms here.
No, the structural inequalities lead to horrific physical realities. Millions of girls face forced child marriage, effectively ending their education and trapping them in cycles of poverty and early pregnancy.
Which brings up a regional treaty that I found absolutely astonishing in its progressiveness. The African Union's Maputo Protocol, adopted in 2003.
Oh yes, the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa.
It is widely considered the most radical, progressive international treaty on women's rights in existence.
More progressive than European or North American treaties. Why?
Because it didn't just adapt Western concepts. It was drafted by African feminist scholars and jurists who intimately understood the specific intersecting vulnerabilities of women on the continent.
Right.
For example, Article 5 of the protocol explicitly and unequivocally outlaws all forms of female genital mutilation.
And Article 14 goes into reproductive rights with a level of specificity that is honestly breathtaking for an international treaty from 2003.
It really is.
It assures women the right to control their fertility, decide the spacing of children, and choose any method of contraception. And uniquely, it explicitly guarantees the right to a medical abortion in cases of sexual assault, rape, incest, or where the continued pregnancy endangers the life or physical or mental health of the mother.
To have a regional treaty explicitly codify the right to abortion in 2003 was decades ahead of much of the global north. It completely subverts the expectation of where progressive human rights law originates.
But again, treaties are just paper. How does international law actually impact a woman living her daily life? I want to look at a landmark case from India that shows how this works in practice.
Oh, the Vishaka case.
Yes, the Vishaka case.
The Vishaka judgment by the Supreme Court of India in 1997 is a true masterclass in how domestic courts can use international treaties to fill a legislative vacuum.
The context is vital here, though.
It is. The case was triggered by the brutal gang rape of Banwari Devi, who was a social worker in Rajasthan trying to stop a child marriage. Her horrific ordeal exposed the absolute lack of legal protection for women in their workplaces.
At the time, India had zero specific domestic laws addressing sexual harassment at work. A woman facing harassment had almost no legal recourse other than general criminal assault laws, which really didn't cover systemic workplace intimidation.
Exactly. So activists filed a public interest litigation. The Supreme Court looked at the Indian Constitution Articles 14, 15, and 21, which guarantee equality and the right to life with dignity.
But they hit a wall.
Right. They recognized that the Constitution didn't have the specific machinery to address workplace harassment. So what did the Chief Justice do? He looked outward.
He looked at CEDAW.
Yes. India had ratified CEDAW. The court ruled that in the absence of enacted domestic law, the contents of international conventions that are consistent with fundamental rights must be read into those rights to enlarge their meaning.
That's brilliant.
The court literally used the principles of CEDAW to formulate what became known as the Vishaka Guidelines.
And these guidelines legally bound all employers in India to establish complaint committees, provide safe working environments, and take disciplinary action against harassers.
It was revolutionary.
The Supreme Court effectively said, since the Parliament hasn't written a law yet, we are going to use this international treaty to write the rules for the entire country.
It transformed CEDAW from an abstract global declaration into binding domestic jurisprudence overnight. It protected millions of women until the Indian Parliament finally passed a formal act in 2013.
This concept of protecting the vulnerable, of recognizing rights where none existed before, it leads us directly into a treaty that completely redefined how we view an entire demographic.
Oh, yes.
Arguably the most universally recognized human rights treaty in history. The UN Convention on the Rights of the Child, the UNCRC, adopted in 1989.
To understand the paradigm shift of UNCRC, you really have to look at how children were viewed for the last 1,000 years.
Basically, they weren't viewed as individuals.
Not at all. They were the property of their fathers or the property of the state. They were economic assets to work the fields or future soldiers.
They were objects of charity, maybe, but certainly not subjects of law.
Exactly. The UNCRC shattered that framework. It definitively declared that a child defined as every human being below the age of 18 is an individual rights holder.
The beating heart of the convention is Article 3, the principle of the best interests of the child.
Yes.
It states that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration.
This completely flips the legal dynamic. In a custody battle or a deportation hearing or even a decision about school funding, the convenience of the adults or the economic cost to the state must take a backseat to what is best for the child.
The architecture of the UNCRC rests on four main pillars. The first is the right to survival, the inherent right to life, health, and an adequate standard of living.
Right.
The second is the right to development, education, play, leisure, and cultural activities. And when we talk about education, the data is just gut-wrenching.
Yeah.
UNICEF estimates that nearly 24 million children living in crisis zones are currently out of school.
24 million. I mean, that is the entire population of a medium-sized country, essentially stripped of their future, trapped in a developmental dark age.
Which is why the third pillar is so critical. The right to protection. Protection from abuse, neglect, and exploitation.
Yes.
Article 32 specifically tackles economic exploitation. It doesn't ban kids from doing chores, but it bans child labor that is hazardous or interferes with their education.
The protection pillar also heavily addresses armed conflict. Article 38 requires states to ensure that children under 15 do not take a direct part in hostilities and explicitly bans their recruitment into armed forces.
Because the reality of modern warfare is just grim.
It is. The insidious reality is that a child with an assault rifle is cheaper to feed and easier to brainwash than an adult soldier. The UNCRC tries to build a legal firewall against that exploitation.
But the fourth pillar is the one I find most philosophically revolutionary, the right to participation.
Oh, this is a big one.
Article 12 states that a child who is capable of forming their own views has the right to express those views freely in all matters affecting them, and those views must be given due weight in accordance with the age and maturity of the child.
It's basically the end of the seen and not heard era.
Yes.
If a judge is deciding where a 10-year-old will live after a divorce, the judge is legally obligated to listen to the child. You cannot just make decisions for them. You must legally factor in their autonomy as it develops.
Okay, let's take a deep breath and step back for a second. We have journeyed through this massive, incredibly intricate architecture of international law.
We really have.
We have the UDHR setting the philosophy, the ICCPR and ICSCR building the dual structure of rights. We have CAT drawing an absolute uncrossable line against torture. We have CEDAW and the UNCRC dismantling historical patriarchy and recognizing the vulnerability of children.
It's a stunning, beautiful blueprint for civilization.
It is. But a blueprint is just paper. It's useless without builders, and more importantly, without building inspectors who have the power to shut down the site.
Ah, the enforcement question.
Fine. Exactly. How is any of this actually enforced? Because the glaring critique of international law is that there is no global police force. There is no UN army waiting to parachute in and arrest a prime minister the second they violate the ICCPR.
And that critique is completely valid. The enforcement mechanisms of international law are often fragile, but they are not non-existent.
Right.
The system has evolved sophisticated ways to generate intense political, diplomatic, and legal pressure. The front line of this enforcement consists of the treaty bodies.
Right. For every major convention, there is a committee of independent experts. The Human Rights Committee oversees the ICCPR. The CEDAW Committee oversees women's rights. The CETA Committee oversees torture. What is their actual mechanism of power, though?
The primary mechanism is the reporting cycle. When a state ratifies a treaty, they legally obligate themselves to submit regular reports to the committee, usually every 4 to 5 years, detailing exactly how they are implementing the treaty in their domestic laws and practices.
But let's be real. If I am the leader of an authoritarian, highly repressive regime, I am not going to send a report to Geneva detailing my secret police's torture methods.
No, of course not.
I'm going to send a beautifully bound 200-page report saying, everything is wonderful, our prisons are like hotels, and equality is thriving.
Exactly. State reports are often highly sanitized propaganda, and the committees know this, which is why the entire system relies on the mechanism of the shadow report.
Okay, explain the shadow report, because this is where civil society fights back, and I find this fascinating.
While the state is preparing its official, glowing report, non-governmental organizations, groups like Amnesty International, Human Rights Watch, local legal clinics, and grassroots activists are compiling their own reports.
The shadow reports.
These are the shadow reports. They gather the affidavits of torture survivors, the photographs of overcrowded remand homes, the statistical data on unprosecuted domestic violence. They send this raw, unvarnished reality directly to the UN committee.
So when the state delegates arrive in Geneva in their sharp suits to present their official report, the committee experts are sitting across the table with a stack of shadow reports in front of them.
Exactly. And the committee uses the shadow reports to cross-examine the state. They ask the hard, highly specific questions the state tried to hide.
Like, you say your prisons are fine, but we have geolocated photos from an NGO showing severe overcrowding in Facility X. Explain this.
Precisely. Following this dialogue, the committee issues concluding observations. These are public, UN-stamped documents that name and shame the state's specific failures and demand targeted reforms.
It's the weaponization of transparency. But what if I am an individual? Say I'm a journalist whose newspaper was shut down, or an activist who was beaten. I don't want to wait 4 years for a reporting cycle. Can I sue my country at the UN?
Under certain treaties, yes, through what are called individual complaints mechanisms. For example, if your country has signed the first optional protocol to the ICCPR, you can file a complaint directly with the Human Rights Committee alleging a violation of your rights.
But there is a massive procedural hurdle you have to clear first: the exhaustion of domestic remedies.
Yes. The UN is not a court of first resort. It respects the sovereignty of the state's legal system. You must first try to get justice through your own country's courts.
So you have to take your case to the local court, the appellate court, all the way up to your national Supreme Court.
Exactly. Only if the domestic system conclusively fails you, or if the domestic process is unreasonably, intentionally delayed, can you knock on the door in Geneva.
Okay, that covers states and treaties. But what about the people who commit the absolute worst atrocities? The generals who orchestrate genocide, the warlords who conscript child soldiers. A committee issuing a strongly worded concluding observation isn't going to stop a warlord.
No, it won't. That requires a different branch of enforcement. International criminal law. The treaty bodies hold the state accountable. International criminal law holds the individual accountable.
And the history of this is fascinating. It really started at Nuremberg and Tokyo after World War II, but those were victorious powers trying the defeated. Victor's justice.
Yes. For decades during the Cold War, the idea of international criminal justice stalled. But in the 1990s, the atrocities in the Balkans and Rwanda shocked the conscience of the world.
They couldn't ignore it anymore.
Right. In response, the UN Security Council established ad hoc temporary tribunals, the International Criminal Tribunal for the former Yugoslavia in 1993, and the International Criminal Tribunal for Rwanda in 1994.
They successfully prosecuted heads of state and military leaders, but they were temporary. They were inherently reactive.
Which is why the international community realized they needed a permanent deterrent. In 1998, they drafted the Rome Statute, which established the International Criminal Court, the ICC, based in The Hague. It began operating in 2002.
The ICC's jurisdiction is strictly limited to the core crimes, right? Genocide, crimes against humanity, war crimes, and eventually the crime of aggression. It's designed to end impunity. It sends the message that no one, no matter their rank, is above the law.
Yes, but the ICC operates on a crucial principle called complementarity. It means it is a court of last resort. It will only step in, investigate, and prosecute if the national criminal justice system is genuinely unable or unwilling to do so. If a country prosecutes its own war criminals fairly, the ICC has no jurisdiction. It is designed as a failsafe against impunity.
We should also briefly mention the regional courts, because they often have sharper teeth than the UN system.
Regional systems are highly effective because the member states share closer cultural, historical, and economic ties. The crown jewel of regional human rights law is the European system.
The European Court of Human Rights in Strasbourg.
Yes, it's incredibly powerful because its judgments are legally binding.
Meaning it's not a recommendation. If the European Court rules that a member state violated the European Convention on Human Rights, that state must comply. They may have to rewrite their domestic laws, release a wrongly convicted prisoner, or pay massive financial compensation.
There's also the Inter-American system, with a commission in Washington, D.C., and a court in Costa Rica, which has been vital in addressing enforced disappearances and amnesty laws in Latin America.
And the African system, right?
Yes, which operates under the African Charter on Human and People's Rights. The African Charter is unique because it codifies not just individual rights, but the rights of peoples, like the right to self-determination. And crucially, it includes the duties of individuals towards their families, society, and the state, reflecting deeply held African philosophical values.
But no matter how powerful the European Court is or how well the ICC functions, we arrive at the ultimate truth of international law. The entire global architecture, from the UDHR to the Rome Statute, means absolutely nothing if it doesn't eventually trickle down and rewrite the domestic law of a specific country.
Exactly.
A citizen shouldn't have to hire a lawyer and fly to The Hague or Strasbourg to get their basic dignity respected. They should be able to walk into a courthouse in their own hometown.
Yes. The ultimate goal of international law is to make itself obsolete by being fully absorbed into domestic legal systems. When a country signs the ICCPR or the UNCRC, the implicit promise is that they will go home and build the local machinery to enforce it.
Which brings us to our final leg of the deep dive. We are going to look at how one massive democracy actually built that machinery. Let's examine India's Protection of Human Rights Act, PHRA, enacted in 1993.
And 1993 is not a coincidental year. We just discussed the Vienna World Conference on Human Rights that took place in 1993.
Right.
The international pressure and the global momentum generated by Vienna placed immense pressure on states to prove their commitment to human rights. India, responding to both this international momentum and domestic civil society pressure regarding abuses, enacted the PHRA.
The core achievement of the PHRA was the creation of the National Human Rights Commission, the NHRC, at the federal level, along with state human rights commissions, the SHRCs, and human rights courts at the district level.
Yes.
But let's focus on the NHRC. If you are going to create a domestic watchdog that is tasked with investigating the government itself, how do you make sure the government doesn't just defund it or stab it with loyalists?
You build institutional armor into the appointment process. Section 4 of the PHRA mandates a highly specific, heavy-hitting committee to select the chairperson and members of the NHRC.
Who on it?
It is chaired by the Prime Minister, but it must also include the Speaker of the House, the Minister of Home Affairs, and, crucially, the leaders of the opposition in both houses of Parliament.
Ah, that's the armor. Bipartisan consensus. The opposition gets a veto, essentially, ensuring that the ruling party can't just install a puppet.
Exactly. And the Act requires that the chairperson must have been a Chief Justice of the Supreme Court of India.
That requirement imbues the commission with immense judicial gravitas. When a former Chief Justice speaks, the executive branch listens.
Right.
So what are their actual powers? Section 12 outlines their functions. They can inquire into complaints of human rights violations or negligence by a public servant in preventing a violation.
And they can do this based on a petition or suo motu, meaning on their own initiative.
So if they read a newspaper report about a police atrocity, they don't have to wait for someone to file a form. They can launch an investigation that morning.
Yes. They can also intervene in any proceeding involving an allegation of human rights violations pending before a regular court, offering their expert legal opinion. But perhaps their most visceral, tangible power is the power of physical inspection.
This is the OPCAD philosophy brought down to the local level. The Act empowers the NHRC to visit any jail, remand home, juvenile detention center, or state psychiatric hospital where people are detained by the government.
Imagine the practical power of that mandate. They aren't just sitting in an office reading police reports. The commission can literally walk onto the dirty floor of an overcrowded district jail.
Wow.
They talk to the inmates, they look at the medical facilities, the quality of the food, the sanitation, and if they find systemic abuse or horrific living conditions, they launch an investigation and demand remedial action from the state government.
They act as the physical bridge. The NHRC is tasked with studying treaties and other international instruments and making recommendations for their effective implementation. They take the lofty philosophical ideals drafted in Geneva or Vienna, and they force the domestic legal system right down to the local police station to reckon with them.
They connect the international blueprint to the local builders. It is the domestication of human dignity.
It's an incredible system, and we have covered a truly massive amount of ground today.
We really have. It's a lot to process.
We started at the philosophical bedrock of the UDHR in 1948 and watched it split into the ICCPR and ICSCR through the crucible of the Cold War. We explored the evolution from retroactive punishment to permanent prevention through the Genocide Convention and the R2P doctrine. We examined the uncompromising, absolute, just cogence nature of the Convention Against Torture.
We charted the paradigm shifts of Vienna in 1993, the substantive equality mechanisms of CEDAW, the radical foresight of the Maputo Protocol, and how the UNCRC transformed children from property into individual rights holders.
And we finally looked at the friction of enforcement, the dance of treaty bodies, shadow reports, the ICC, and how it all culminates in domestic machinery like India's PHRA in 1993.
Yeah.
It is a staggering amount of legal architecture.
Truly staggering.
But why should you, listening to this, care about all these acronyms, these covenants, these conventions? Because these are not abstract texts debated by diplomats in sterile rooms. These laws are the invisible structural force fields protecting your daily life.
Absolutely.
They are the intricate machinery that ensures you have the freedom to speak your mind, the right to expect fair pay, the right to autonomy over your own body, and the guarantee of physical safety if you are ever detained by the state. The international human rights framework is the ongoing, incredibly difficult attempt to civilize power.
But as we close this deep dive, there is a fundamental, inescapable paradox at the heart of everything we've discussed. A paradox I want to leave you to wrestle with.
Okay, let's hear it.
This entire intricate system of international law relies on sovereign states voluntarily signing treaties to limit their own power. The state is historically the primary violator of human rights. Yet the state is also the only entity that possesses the police forces, the military, and the domestic courts required to enforce these treaties. We have built an elaborate system where we are relying on the fox to guard the henhouse, and our only security is that the fox signed a piece of paper in 1966 promising to become a vegetarian.
Wow. Which brings us back to our broken X-ray machine. We want a clean, simple diagnostic of justice. But what we have is a messy, constant, incredibly fragile negotiation of power.
Exactly.
So the provocative thought we leave you with today. How does this paradox survive the 21st century? In an increasingly borderless digital world, where transnational tech corporations wield more economic and surveillance power than most governments, and where algorithmic bias can strip millions of their rights in a microsecond, where does the ultimate power to enforce your human rights truly lie?
Is it in the halls of the UN in Geneva? Is it in a courtroom in The Hague? Or is the architecture of human dignity migrating somewhere else entirely?
It's a question the law hasn't quite answered yet. Something to deeply consider. Until next time, keep diving.